We've given the we've given the 5-minute warning or grace period to let people get to the space. So I want to go ahead and honor the time and we can get started. Welcome to our presentation today. By way of introductions, there will be two of us that are presenting today. I am Carmen Ayers. I go by she, her, hers. I am the Housing Priority Coordinator for Legal Action of Wisconsin. I am located in the Racine office, and I serve the counties of Racine, Kenosha, and Walworth. And I will let Corey introduce himself.
And I'm Corey Lundeen. I'm also an attorney with Legal Action. I'm based out of our Madison office, he, him. I work in Dane County and pretty much all the counties surrounding Dane County.
Okay, so the reason why we're here today is to talk about Rule Petition 2203. That's the rule petition that we thought maybe had died in the water, but it has been resurrected now. We filed this petition because we were concerned about the retention rates of eviction records on people's backgrounds. And so we wanted to address that issue and try to minimize the impact it had on people trying to rent after they've had an eviction action against them go through the court. And this particular petition will ultimately change the way that they keep the records. It's not going to change the process, but it's going to impact the way that the state and the county clerks hold on to and retain eviction records in cases, especially if there is no money judgment. So if the person doesn't owe anything to the landlord, we're hoping to greatly reduce the amount of time that it sits on CCAP for people to look up their records or pull. Right now, it's currently set at 2 years, and so we're trying to reduce that down to 1 year. Right now, the clerk of courts could dispose of these cases with no money judgments, and then it wouldn't appear on the court records, and it also wouldn't be able to be pulled in the clerk's offices. So we want to tell you why we have you here, and that is because the Wisconsin Supreme Court wants to hear from us and those who are in support of this major change to the way that they conduct the records currently. And so we want to share with you when that public hearing is going to take place and when you could potentially use your voice to help support the work that we're doing. And that will be on Thursday, September 7th of this year at 9:30 a.m. in Madison. And so now, if you are wondering where that public hearing is going to be taking place, we're going to share that with you now. It's going to take place at the Supreme Court of the state of Wisconsin, and it's going to be in the hearing room in the East Wing on the 2nd floor. And we are recording this, so you don't have to think that we're rushing or that you somehow didn't take notes. We will be sending this to everyone who registered for today's presentation. And so now to give you a little back, oh, Corey, this is your part, sorry.
Not a problem. So this is a unique opportunity for this Wisconsin Supreme Court to hear from the general public. Usually the court, when they're in session, they're hearing legal cases and they're hearing from attorneys. And so they will have attorneys come in, each give both sides of the case. They limit the attorneys to the time limit. With rule petition hearings, they are open to the public. Anybody can register to speak to the Wisconsin Supreme Court and talk about the pending rule petition. Most rule petitions are about Supreme Court rules that govern, for example, rules of ethics for attorneys, judicial ethics, how we handle client trust accounts, things that usually non-attorneys don't really care about too much. And so they don't get much public attention. This is a hearing on a rule petition that has a lot of public interest. So we expect there's going to be a large number of people who are going to be registering to speak. Carmen and I will be presenting the rule petition on behalf of Legal Action. We'll be taking care of explaining to the court why Legal Action filed the rule petition, the legal arguments in support of it, the legal arguments against the opposition to it. We'll be taking care of that. But it is an opportunity for the Supreme Court to hear from the general public as well. It is going to be time limited, and we expect that the court is going to give speakers only about 2 minutes of time to speak. The hearing will get started at 9:30. We're waiting to hear from the court about how long that hearing will last. It could last just that morning. It could extend into the afternoon. If you are planning on appearing, you should plan on appearing at 9 o'clock to make sure that you're there on time so that the clerk's office knows that you're there on time. But you should be prepared that you may have to wait a while for your turn to speak. Carmen and I's presentation will probably take 20 to 30 minutes. We expect a landlord group will probably get significant time as well. Carmen and I will have an opportunity likely at the end to wrap things up, but it is expected that you may have to wait there for quite some time before you're able to speak. And once you do get an opportunity to speak, just like the court times attorneys when they're doing oral arguments on cases, they will time the speakers. There's usually a little green light and red light that will indicate the time. And so if you are planning on speaking, we'd encourage you to try and write out and prepare your remarks to make sure they're under that 2-minute limit. It's possible the court may give speakers more than 2 minutes to speak, but in our experience, they usually give public speakers only about 2 minutes to speak. So plan for 2 minutes. If they give speakers more time, that's great. But you should plan on only 2 minutes and be prepared for that, because they will literally cut you off in the middle of the sentence when they get to those 2 minutes and ask you to wrap up your sentence. So it's good to have that prepared out in advance, written out and practiced before the hearing. What would we like you to talk about? Well, obviously you all know what the experience that renters with eviction records face. Carmen and I will be able to talk about the legal arguments in support of the rule petition, but we're encouraging speakers who have unique or diverse voices or stories to tell the court about the problems that renters with eviction records face. We'd also encourage people to provide, unique stories. If there's several people from one organization that are planning on speaking, it would probably not be helpful for the court to hear everybody from that organization say exactly the same thing, but rather each speaker talk about something different or tell a different story about why they're in support of the rule petition. I guess I'll stop there for a minute and see if anybody has any questions about that before going on. And as always, feel free to jump in along the way if folks have questions.
Corey, we did have one question in the chat. The question was whether or not the hearing would be recorded.
It will be. So you will be broadcast live on Wisconsin Eye. That's the public access station that broadcasts things that happen down at the Capitol and also public interest programming. So it will likely be broadcast live. So if you're not able to attend the hearing, but you're interested in watching it, you can watch it on Wisconsin Eye Live. It will be available then for approximately a week after the hearing for you to watch for free. After that, it goes behind a paywall. You need a Wisconsin Eye account, a paid account, in order to access recorded hearing after a week's time. But you would be able to watch it while the hearing is going on and for a week afterwards, unless you have that paid account with Wisconsin Eye. Folks will be appearing before the Wisconsin Supreme Court, so dress appropriately, and you're going to be broadcast live for people to watch. And I see it looks like Barbie, you have your hand up and have a question?
Yes, thank you. So those of us who are from Moses are working on a housing group that is part of our efforts to eradicate the childhood to school to prison pipeline. And most of us are not directly impacted by this situation, but we're advocates for the negative impacts that it has. So I have two questions. I mean, first of all, let me say we do have access to formerly incarcerated people who may indeed have personal stories to share, and we will be looking to that. I've read through your petition argument information, and there's lots of really useful information in there that we could significantly just, pick out little pieces of that and tie it to what our concerns are. Would that be something that would be appropriate and helpful, or is that just redundant of what you've said?
I think it would be helpful for you to, because you can speak to the experience that you've had with the people that you're helping out and what issues they've had. Carmen and I can talk about the stories that our clients have, but that's only our client stories, and we don't represent every single renter in the state of Wisconsin. So having those unique, voices, I think would be helpful. Particularly if you have a particular story of a client or somebody that you're working with who had a problem with eviction records, and so that made it difficult for them to find housing. Nothing about our rule petition will change the impact that criminal records may have on somebody's ability to find housing. So it's not going to impact that, just the eviction records. And I saw my colleague, attorney Heidi Weckleitner, wanted us to kind of give a brief overview. Like Carmen said, what this rule petition would do would simply change the amount of time that the clerk of courts need to hang on to the file. After a year, the file could be disposed of and wouldn't appear online on the Wisconsin Circuit Court access page. People usually refer to that as CCAP. That's the web page where you can go, type in somebody's name. If they've been involved in a court case, their name will probably pop up on there. Eviction records stick around for 20 years, but many eviction cases come off CCAP after only about 2 years. But there's a lot of cases that will remain and be available even down at the courthouse for you to take a look at. So this would change the ability of the clerks to be able to get rid of those files. The one thing it would not do would be, it wouldn't get rid of cases where there's a money judgment entered against the renter. Those cases would still remain for 20 years. And the reason for that is because 20 years is the period of time somebody who has a money judgment against somebody else, that's the period of time that they have to try and collect on that money judgment. So those are cases that we can't get rid of after only a year, because if there's a money judgment entered, the landlord has 20 years to try and collect on that judgment.
Barbie,
Go ahead.
there's one other thing I wanted to reiterate with the question that you asked. I think it's important for both the voices of the advocate and the voices of the impacted individuals. So don't just simply look for people to tell their stories. I think it's important for both because, one, their story may be compelling as a whole, right? But the work that you do as advocates, you touch so many more lives and you have so many more viewpoints and vantage points because of the interactions that you have to be able to talk on a wide basis. So you can say, if you have statistics, how many people you've had contact with, how many of these people have had these complaints, whereas it's just a one-off story if you only have the voices of, but I do think both voices are very important. I don't think that one is more important than the other. So if there's a possibility to have both an advocate present and an impacted individual present, I think that is the most compelling stories and the most impact, especially because the group and the subset of clients that you help or individuals that you help are often an unheard population that have needs that are very significant, and this could change the trajectory of whether or not they're reincarcerated. So I think that's a viewpoint that most people don't get to hear on a day-to-day basis or put a human face to. So I think the work you're doing and the people you could bring to the table will be very important for us.
Absolutely, Carmen. And like I said, this is a unique opportunity for people to speak directly to the Wisconsin Supreme Court. Even when attorneys are arguing cases in court, their client may be sitting next to them in court, but their client isn't going to talk to the court. This is an opportunity for any member of the public to show up and be heard, put a face to the problem that eviction records have with renters. And so it is a really unique opportunity. Any other questions that folks have about how the hearing might work, what you might speak about, those sorts of things before we move on? All right. All right, so how do I get on the list of speakers? Here's the contact information for the folks at the Wisconsin Supreme Court for you to email. Like Carmen said, we're going to be sending out the slides from the presentation as well, so you can take this down now. We'll send it out to you afterwards to make sure that you have it. These are the two people at the Wisconsin Supreme Court who you can email. I would suggest in the subject line putting Rule Petition 2203, public hearing, something to that effect, so that they know you're emailing them about Rule Petition 2203 and the public hearing. We should be able to share the recording link. We'll get that out to folks after we get done recording things. We'll send out the link to the recording, the link to the slideshow. So that's who you can contact. I would recommend, if you're planning on speaking, I would recommend emailing these folks sooner rather than later. The sooner you email them, the earlier up on the list you will be for the list of public speakers. Carmen and I get priority because we're the petitioners. Legal Action is filing the petition, so we get to go first. After that, it's going to be very much up to the court to decide about the order that they go in, but generally they're going to go in the order that people sign up for members of the public. I might also suggest that if you have a name like mine, for example, that may be difficult to pronounce, you may want to include in the email how you pronounce your name so that the court knows that, because they will be calling you in the order that they have you on the list. If you have concerns about them not being able to pronounce your name, I have a last name that is mispronounced all the time. It's Lundeen, not London, even though that's how it's spelled. So I would suggest including that in the email as well.
Mhm.
It is possible, if you want to just show up and talk the day of, you can do that. But you're going to be placed probably at the bottom of the list of speakers, meaning if you show up at 9:15 to the Wisconsin Supreme Court and say, hey, can I be added to the list of speakers? You can be added to the list. I would just be prepared that you're going to be waiting around until the hearing is getting close to being done before your name is going to be called, because you will be on the bottom of the list.
Additionally, if they've only set aside a certain amount of time and you wait until the day of the hearing, there's a potential you won't get heard at all, and you will have spent all day there without being heard. Once they know who's registered to speak, they'll better gauge how long they want to set aside on their calendar. So if you really want to make sure that you and others you know are heard, I would suggest emailing in advance.
All right, any other questions that folks had? And I want to leave, yeah, Barbie, I see your hand is up.
Sorry, I have lots of questions, and since no one else is asking. We're accustomed to testifying in front of the Dane County Board and the state legislature and the school board and all those, and they have a mechanism for being able to submit written testimony as opposed, is there a mechanism for that?
There is not. There was an opportunity for written comments to be submitted last summer.
Saw that, yeah.
Unfortunately, that was over a year ago, that the time for written comments. It is possible the court could put out another request for written comments. That is very unlikely. It's possible it could happen, but I wouldn't count on it. The opportunity for comment is probably the only opportunity for comment at this point we should assume is going to be at the public hearing. The opportunity for written comments happened a long time ago. We filed our petition back in March of last year. The Supreme Court put out a request for comments last summer, and the time period for that is unfortunately long come and gone.
Mm-hmm. And then just one other thing, and this is just a point of clarification. I've read your materials and I keep getting confused about the 2-year limitation versus the 20-year. I heard what you said about if there's a finding that involves money, but some of what I've read I thought sounded like the 20-year retention period.
Sure.
Even where there was not a money award.
Sure. So there's the retention period, which is the amount of time the clerk of courts has to hang on to the file. And that for most cases is 20 years, for most eviction cases is 20 years. But there's also then the time period when it is displayed on the WCCA website. And that is for most eviction cases where there is not a money judgment or a judgment of eviction granted is only 2 years. So as an example, let's say an eviction case is filed, legal action gets involved to represent the renter, we end up working out an agreement, and the case is dismissed. That's how most eviction cases are resolved. Those cases will be retained down at the clerk of court's office for 20 years, but they will be displayed on WCCA for only 2 years. WCCA is the court's website. People usually refer to it as CCAP. It's not. CCAP is the court's internal court computer system. So everything on WCCA, the website, is in CCAP, but not everything in CCAP is on WCCA. As an example, juvenile court records, child protective service records, mental health commitments, adoptions. There's all sorts of court cases that the courts have records of that never show up on the court's website because they're considered confidential cases. So CCAP is the court's computer system. WCCA is the court's website. Right now, most eviction records are retained on CCAP at the courthouse for 20 years, but only appear on WCCA for only 2 years. That's the result of a decision made by the court system a few years ago. It used to be that those records would show up for 20 years on the website, no matter what. They changed that display period on the website down to only 2 years, starting a few years ago. For eviction cases that were a stipulated dismissal and no judgment of eviction was ever granted. If there's a judgment of eviction granted, that's going to be a case that shows up on WCCA for 20 years. Our rule petition would shorten the records retention period for all eviction cases where there is no money judgment entered to only 1 year. What that means is that after a year, the clerk of courts can get rid of that court file and destroy it. It also means that after a year, it will automatically come off WCCA, the court's website, regardless of whether the clerk of courts still hangs on to the file. And then I see, Patricia, you have your hand up?
Yeah, I do have a question. I'm on the HSC board this year, and I know that they and many other groups were writing in support of what you submitted in March. So are you broadly inviting and they may, encouraging people and providing some structure like you are for us now, around the state or within the county, or is it? I'm sure it's pretty widely known that it's come up to all those entities, but I'm curious by the short turnout small turnout right now.
Yeah, we're looking at trying to get as many people from around the state to come. For example, our colleagues at Wisconsin Judicare Legal Aid up in the northern half of the state, we reached out to them. We want to try and get a broad and diverse group so that, because this isn't a problem that is just a Madison, Milwaukee, Racine problem. This is a statewide problem. It's not a problem that just impacts renters in the big cities. It is a problem that impacts renters everywhere. We're reaching out to all the folks who commented in support of the rule petition, which was a broad group outside of Madison and Milwaukee. There were lots of folks commenting from La Crosse, from Janesville, Beloit, from other areas of the state. So we are hoping to have a broad group of people at the public hearing.
Thanks.
And we know this time doesn't work for everyone, so I'm not concerned about the small group that's
No.
here. We've cast our net wide. We have contacts, and obviously we did a really good job rolling this out back in 2022 and had a lot of participation back then. And we are circling back to everyone that did do a written response so that we don't have overlap in what we do as far as the hearing goes, because we do want to maximize what they hear and who they hear from. So we don't want to have repeats of the same thing over and over again. And yes, absolutely hooray that there has been a change in the court. We were doing this on a whim when we originally filed, and we feel like we might have better success now that we've had a little bit of change in organization of the court.
And that too is why we're recording this, is we know not everybody could make it at this time on this day on short notice. So that's why we're recording, to make sure we can distribute this to folks who weren't able to make it today. All right, anybody else have any other questions at all? Well, if you do, Carmen's contact information is up there. My contact information is out there. Like we said, we're going to be sharing our slides. We'll be sharing a link to the recording once we get that set up with Zoom, so that people will have that. Feel free to share widely. If folks talk with people and maybe they don't know about this rule petition, but they're interested, perhaps interested in speaking, have them get in touch with Carmen or I. We'd be happy to talk with them, answer any questions they might have.
Also, if you know some landlords that are friendly and would be helpful to speak, we would love to see landlords that aren't antagonistic against what we're doing too. So if you own some properties or know someone who owns some properties that could say, like, this could be beneficial, that would be helpful too. So thank you.
Well, thanks all for attending. We hope to see some of you hopefully at the public hearing. And as always, if you've got questions, reach out to us.